Hi, I'm Jonathan and I'm a lawyer in Queensland. And this is the second in a video blog series designed to help people to represent themselves in the domestic and family violence courts in Queensland. This video is about what the court needs to be satisfied of in order to make a domestic violence protection order. So, if you're making an application, you need to make sure that your application covers these things. And if you're responding to one, you can check that the application against you covers each of these things. The three things that the court needs to be satisfied of in order to make a domestic violence protection order are: one, that it's the right kind of relationship so that the Domestic and Family Violence Act applies. Secondly, that domestic violence has been committed against the aggrieved. And thirdly, that it's necessary and desirable for the court to make an order. So let's talk about what each of those things mean. So firstly, what is the right kind of relationship so that the court can make a protection order? Well, there are three types. Firstly, an intimate personal relationship would include a married couple, de facto partners, or anyone in a couple relationship, or anyone who previously has been in any one of those things. Also, anyone who has a child together would qualify. It needs to be more than just one or two dates. The second category of relationship is family relationships. So obviously that includes parents, brothers, sisters. It also includes step families and relatives by blood or marriage. The third kind of relationship is an informal care relationship. So that's where one person's caring for another. It might be because of old age or a disability, and they're not workers in some kind of institution like an aged care facility, or they're not paid carers. It is okay though if they're receiving a Centrelink payment as a carer for that person. So what about children, that is persons under the age of 18? Can you get an order protecting you against a child? Or can you get a protection order protecting a child against someone else? Well, you can to both of those questions, but only if it relates to an intimate personal relationship or an informal care relationship. In Queensland, the court can't make a family violence protection order between two people in a family relationship where one of them's a child. In other words, you can't take an order child under 18 against parent, parent against child under 18, sibling against sibling under 18. However, you can name a child on someone else's order. For example, if mum was to take an order against dad and the children have been exposed to the domestic violence or have experienced associated domestic violence, then the children can be named persons on mum's order, and you can have conditions protecting the children under the mother's domestic violence order against the father. The second thing that the court needs to be satisfied of in order to make a domestic violence protection order is that domestic violence has been committed against the aggrieved. So what is domestic violence? Well, it's behaviour or a pattern of behaviour that is abusive. It could be abusive physically, sexually, emotionally, psychologically, economically. It could be coercive behaviour, it could be threatening behaviour, or it could be controlling or dominating behaviour. Other acts of domestic violence which are worth noting are unauthorised surveillance. For example, monitoring someone's activity, their whereabouts, their emails, their messages without their permission. Also, threatening self-harm in order to frighten someone or threaten them or coerce them into doing something. It's really important to be specific about what is the behaviour that the court should find is domestic violence. For example, lots of people come to the court and say he or she would do this over the course of our relationship. What the court needs, though, is what we call particulars. Who, when, what, how. So be as specific as you can with the time frame. When did it happen? Where were you? Who was present? What were the circumstances that led up to that event? And when you're quoting someone, use quotations. Rather than saying, he said that I was a rubbish parent. Say, he said, you are a rubbish parent. If you're not sure that those are the exact words, you can say, he said words to the effect of, you are a rubbish parent. The third question that the court must consider in deciding whether or not to make a domestic violence order is whether it is necessary or desirable to have an order to protect the aggrieved from future domestic violence. So this is basically a risk assessment. You need to include the facts in your application that are relevant to whether there is a risk of future violence. For example, if the parties are going to have ongoing communication, for example, about the parenting of children, then there might be a risk of future violence. If, on the other hand, the court finds that a period of time has passed and there's been no domestic violence, then perhaps the court will consider that it's not necessary to have an order. Or if there's been a significant change in circumstances, for example, the parties no longer live near each other, then the court might decide that it's not necessary to have a domestic violence order in place. And in making the decision as to whether it's necessary or desirable to have a protection order in place, the court will always come back to the paramount concern, which is the safety, protection, and well-being of those who fear or experience domestic violence, including children. So in this video, we've covered the main things that the court considers in determining whether or not to make a domestic violence protection order. I hope it's been helpful. If it is helpful, please subscribe to my channel, and I'll be making more videos to help people to represent themselves in domestic and family violence court proceedings.